open the door. Your lordships tell us as a country where the law stands and where our constitutional values stand. And then, my lords, a social debate happens, a legislative debate happens, and my lords, we as a country, we adhere to the constitution. Please, my lord. I'll just put 3 points before my lords. The first is that my lords are contemplating whether the constitution recognizes a fundamental right to marry. That, my lords have indicated, perhaps may be found across the rights that are enumerated in part 3. And, my lord, that the right to marry would have certain contents which are already recognized under law through various statutes. My submission in this regard would be that it fell from your lordships on the previous date that the contents would include, my lords, for example, the right to found a family, the right to procreation, and so on and so forth. The first content I would submit, my lords, of this right to marry must be the status of being married itself. This is, my lord, distinct from the rights and obligations that flow from a marriage. The status of being married, my lord, the recognition of the relationship itself confers a couple with dignity. This is, my lord, dehors any rights and obligations that flow from the marriage. And therefore, my submission, my lords, that the first right, my lord, that is recognized, the first content of this right to marriage, my lord, would be the recognition of the marriage itself and the status of being married.
Yes.
Please, my lord. That's my first submission. The second submission, my lord, is this, that it was indicated to your lordships yesterday that if my lords were to give such a declaration, it would bind future parliaments. It would bind future courts. And that is the nature, my lords, of Article 141. It is inherent, my lord, to the obligations of this, the constitutional obligations of this court. In Nalsa, my lord, the formulation and Nalsa, my lord, as the nodal judgment when it comes to questions of gender identity and sexual orientation, the formulation that this court gave was first to indicate, my lords, the content of Part 3 rights when it came to transgender persons, and then, my lord, to actualize those rights through specific directions that your lordships gave to central and state governments. So, my lords, I'm completely with my friends on this side that any declaration that your lordships give must be actualized through an enunciation of the Special Marriage Act. But in addition, my lords may see the declaration that your lordships have given in Nalsa, and I believe my note may have reached your lordships too late to be uploaded, so I won't trouble your lordships with it. But, my lord, in para 135, in conclusion in Nalsa, your lordships gave detailed directions. These, my lord, included directions to recognize transgender persons as a third gender, directions to central and state governments to recognize transgender persons in their self-declared gender identity. And all these directions, my lord, were traceable to the enrichment of Part 3 rights that your lordships recognized. I won't break the convention of this court, my lord, by handing over physical copies of my note. I'll just continue. But the third, my lord, was a very valuable direction to extend Article 16 for protections to transgender persons. So transgender persons were found to be a historically backward class. And this, my lord, perhaps may be the first time that the concept of historical backwardness was expanded to include a new community, what is now being done with EWS, my lords. The next direction to central and state governments was to address health issues of transgender persons. For instance, my lord, directions to NACO to set up sero-surveillance centers, or, my lord, to provide separate toilets. So here the direction, my lord, aside from the declaration of law, the direction, my lord, was traceable to the right to health under Article 21. There was also a direction, my lord, to the central and state governments to address the problems of fear, shame, gender dysphoria, etc. So therefore, my lord, to bring about a change in social values regarding transgender persons. This is the extent, my lord, of the directions which were given in Nalsa, along with the declarations. And finally, my lord, direction to the central and state governments to frame social welfare schemes, which are also traceable to Part 3 rights. Now, what has been the effect of the directions coupled with the declaration that fell from my lords in Nalsa? Did Parliament stop debating the issue, or various state legislatures? as has been indicated to my lords? Did social debate on these issues stop? Not at all. What happens, my lord, is we now have many states, including the state of Madhya Pradesh, for example, which have brought about policies for the welfare of transgender persons. The and my lord, my friend Mr. Dwivedi appeared on behalf of the state of Madhya Pradesh. But like me, my lord, he is from the great state, may I say, of Uttar Pradesh. And my lord may see what the state of Uttar Pradesh did, following my lord's directions in Nalsa. The 7th State Law Commission, my lord, in Uttar Pradesh, entirely relying on my lord's directions in Nalsa, finds that they have been directed to improve the conditions of transgender persons and specifically take up the issue, my lord, of laws of inheritance. So, what do they say, my lord? The Hindu Succession Act as well as the Indian Succession Act are central legislations, and although the state government has power to amend these legislations with the concurrence of the central government, this has a long procedure. Therefore, this commission has confined its study to the right of succession in agricultural property as well as the grant of lease regarding Abadi lands in Uttar Pradesh. And what, my lord, has the great state of Uttar Pradesh, for which I'm a proud citizen, my lord, of Allahabad, has it held? They amend the Uttar Pradesh Revenue Code in 2020, and what do they introduce? The family in relation to a tenure holder means himself or herself and his wife or her husband or third gender spouse. This is the current state of the law in UP, my lord. As the case may be, other than a judicially separated wife or husband or third gender spouse, minor sons, minor daughters, other than married daughters, and third gender minor issue. So, not only, my lords, following your lordship's declaration and directions in Nalsa, not only do state legislatures now recognize third gender children as successors to the estate, they also recognize the possibility of third gender marriage, of marriage of third gender persons, as the statute calls it, and in fact, even situations where there may be a judicial separation of such persons. And thereafter, my lord, they are incorporated into the degrees of succession as the RAN revenue codes imagine, my lord. So, my lord, my submission is that your lordships open the door. Your lordships tell us as a country where the law stands and where our constitutional values stand. And then, my lords, a social debate happens, a legislative debate happens. And, my lords, we as a country, we adhere to the constitution. We bring ourselves, we rise, my lord, to the level of the constitution. The last submission I'll make is this. Your lordships have in effect been told that because there's a vast problem of statutory interpretation before my lords, your lordships should not touch the constitutional issue. That your lordships will be so troubled by a question of statutory interpretation, however frequently it may arise, my lord, and however many statutes it may arise. But if I may just submit to your lordships, if my lords take yourselves back, perhaps 15 years or maybe even more, when my lords sat as single judges in the high courts, and perhaps, my lord, a young Justice Narasimha then appears before my lords. And my lords, these issues come up, my lords, in MAT FCs, in MAT appeals, in FAOs. And they are questions, my lords, then of statutory interpretation. They arise, my lord, in individual cases relating to individuals who come before my lords in many combinations, as my Lord Justice Bhatt has put to us throughout the course of these proceedings. My lords, look at the facts. And my lords, this is why, my lords, we are not running away from a question of statutory interpretation. We are not saying that these questions are insurmountable. It was asked in this court, my lord, who will be the father or who will be the mother? My lords will look at the statute, as my lords would have done 15, 18 years ago. Look to the statute, look to the law and the declarations laid down by the Honorable Supreme Court, and will find solutions for the persons who come before them. Because, my lord, Parliament can choose when it decides to address an issue. Parliament can choose, there may be a social problem, and Parliament can turn a blind eye. But, my lords, your lordships, the high courts, and the courts below, the family courts, the civil courts, they do not have that luxury, my lords. When persons raise a list before your lordships, when they come with a cause of action, the courts have to address those questions, and they have already been so doing. There are cases going back to the 1990s, my lord, where transgender persons have come